The final witnesses today are the two commissioners who are part of the Melbourne response, Mr O'Callaghan QC and Mr Gleeson QC. Would you introduce yourself, Mr O'Callaghan?
I'm Peter O'Callaghan. I'm an independent commissioner of the Catholic Archdiocese of Melbourne to inquire into allegations of sexual abuse by priests, religious and lay persons within the Archdiocese. I have been in that position now approaching 19 years, and we trust and thank the Commission for the opportunity, and we trust that our experience might provide some assistance in the difficult task you have to undertake.
Mr Gleeson.
And my name's Jeff Gleeson. I'm a barrister at the Victorian Bar. I've been an independent commissioner since August 2012, and before that I was counsel assisting Mr O'Callaghan for more than 15 years.
Can I invite you to speak to your submission?
Yes. If the Commissioners, please. We have stated in our paper the people for whom we don't speak, because our role is a limited one. What we would submit is to commend our paper to the Commission and to point out that in the Commission making recommendations both as to interim arrangements and as to final arrangements, we submit you will be assisted by looking at the operation of those entities who have in fact addressed the issue of sexual abuse in the past. And whilst we submit that the Melbourne response has operated in a satisfactory manner, to which I will briefly elaborate, we stress that when we say it's operated satisfactorily, that is not to suggest that it can achieve what is impossible to achieve, and that is to eradicate from the mind of the survivor victim the scourge of the abuse. But having said that, the terms of appointment have only been amended in an irrelevant way for this hearing in 2011 and 2002. And it naturally, and I speak both for myself and for Mr Gleeson, that we have addressed the issue of whether the system that we are a fairly significant part of has operated satisfactorily. And we respectfully submit that it has, and indeed if it hadn't, we would have had a duty to bring that to the attention of our appointors. So we submit that the Commission may well be assisted by looking at the experiences of not only the Melbourne response, but the other organisations that have embarked upon dealing with the issue of sexual abuse. Now, obviously, our primary interest is to address or to put forward the situation with relation to interim arrangements, which will bind us for some little time perhaps before final recommendations can be made and implemented. And I don't propose to repeat what we've said in the paper, but a prevalent and naturally an obvious concern of the Commission as expressed here today and otherwise is the standard of proof. We have endeavoured in the paper to refer to the way in which the standard of proof of the balance of probabilities, quotes Brigginshaw, has applied since the operation of the Melbourne response, which has dealt with well over 350 complaints, all of but a handful of which have been upheld. And my said my learned friend, but Mr Gleeson will deal in more detail with that in a moment. But we, in effect, submit the traditional means of a proper satisfaction is to adopt the Brigginshaw test. Once upon a time it was said to be wrong to try and elaborate upon the meaning of reasonable doubt and to elaborate upon the meaning of the balance of probabilities. We are now spoken of in various grades of plausibility, reasonable satisfaction, and the WADA codes and the ASADA codes have a standard of proof called comfortable satisfaction. But in the light of the time, I will cease at this point and pass over to Mr Gleeson.
Thank you. The issue I wish to address is the standard of proof and the process of assessing claims. We understand that the Royal Commission's quite proper with respect to concern that substantially motivates the consideration of the appropriate standard of proof is the need to avoid or minimise the prospect of victim survivors being re-traumatised by the process of applying for redress. It's been my experience over almost 20 years that it is possible to balance the application of the Brigginshaw standard with a fair and compassionate approach to applicants. The very act of a survivor victim revisiting the horrors of their childhood sexual abuse will inevitably be a troubling and often distressing experience, regardless of how the application is made. The significant majority of applicants I have dealt with accept that revisiting their sexual abuse is very difficult but necessary, and I would describe their experience as falling well short of re-traumatisation. I certainly hope that's the case. The Royal Commission has identified the receipt of a meaningful apology as being extremely important to victim survivors, and that's consistent with my experience of what they say. You'll understand that claimants, many of them speak expansively about what they've endured and what they hope to achieve by telling people about it. One consideration that I offer up is that an apology based on a lighter standard of proof than the Brigginshaw standard runs the risk of being less meaningful and therefore of less benefit to the victim than an apology based on the higher standard. The two standards that have been raised for consideration in the consultation paper are the standard of plausibility and the standard of reasonable likelihood, in addition to reference to the other standards. The standard of plausibility is described in the consultation paper at page 170 as a satisfaction, and I quote, that the allegations are plausible and may be true. The standard of reasonable likelihood is described at page 170 as higher than plausibility but lower than balance of probabilities. As both of those standards are lower than the balance of probabilities, they contemplate that a claim would be accepted even if it is more likely than not that the abuse did not occur. I hasten to add that it's my experience that there's been very, very few complaints that are not genuine and accurate. But we're addressing a proposed adjustment or a proposed system that has a different approach to that which I've experienced. And I'd respectfully observe that the consultation paper appropriately identifies the importance of belief and being believed. There's a reference at page 132 to a person who says, "At last I was believed." And there is a risk, I believe, that if a plausibility standard, for example, is adopted in any new system, that the implicit message conveyed to a successful applicant is, "We believe you may have been abused." Under the Melbourne response, with its Brigginshaw standard, 97% of applicants have been able to say quite legitimately, I've been believed that I was abused. The consultation paper speaks of the apology process only being available from the institution, logically enough. There may be difficulties in obtaining a meaningful, that is, specific and direct apology from an institution in respect of claims which may be more likely than not to have not occurred. It is, in my respectful submission, very important to victim survivors that the apology that they receive is perceived by them to be genuine and specific to what they've suffered. And there is a risk, I think, that the apology in a system with a plausibility or reasonable likelihood standard of proof might fall short of that. Our submission has referred to the difficulties associated with a process that does not identify the person who committed the sexual abuse. There is a concern that arises from the suggestion at page 176 of the consultation paper, and I quote from that this passage: "The scheme might wish to consider the outcome of any disciplinary investigation before determining an application if the abuse is recent or fairly contemporary and the alleged perpetrator is still involved with the institution." So there's the introduction of the notion of some interplay between the disciplinary process specific to an institution outside the scheme and the operation of the scheme itself.
Mr. Gleeson, can I just remind you of the time? We've passed the 10-minute mark.
I'm sorry. I'll just wrap up that point, if I might. The concern that it raises is the possibility of there being, in practice, two different standards, one for cases where the alleged abuser is alive and still involved with the institution and one where they're not. My experience suggests that what victims overwhelmingly want is a process where the abuser is identified and not sidestepped. That is, the issue of identification is not sidestepped.
Mr. Gleeson and Mr. O'Callaghan, thank you for your careful submission. I do want to take you up, though, on this question of the standard of proof and also the identification. As you know, I come from New South Wales and I've sat in the Court of Criminal Appeal in relation to cases of abuse occurring within Catholic boarding facilities where children have been abused in the night, having been taken from their beds by an abuser. The issue in the Court of Criminal Appeal has been, does the evidence rise to beyond doubt that it was a particular brother who did the abusing? Because it's in the night, there's no light, there's a cassock or some other garb, and there can be no doubt on the evidence that you look at that the person as a child was abused. But to be satisfied to Brigginshaw that it was necessarily the person who they think it was as opposed to a different brother may be difficult. Now, what you're suggesting does seem to be at odds with what I have experienced myself.
Well, if I could respond to that, Mr. Chairman, if there is doubt in the mind of the victim or the survivor as to who it was who abused him or her, that can be stated. They can say, and indeed there's been plenty of cases that we've upheld, by the victim not being able to identify precisely the person who did it otherwise than that a person did it. And on the Brigginshaw test, that was adequately sufficient to warrant finding that...
I must have misunderstood your submission then. I must have misunderstood what you just said too, Mr. Gleeson.
I'm sorry, sir. No, I think our submission says, and I certainly want to say now, that the inability of a victim to identify a particular person as the abuser does not, in my view, prevent a finding to the requisite Brigginshaw standard that the abuse occurred. Can I give a small example? At the moment I have a claim that I'm investigating by a person who alleges that they were abused by, repeatedly sexually abused by a brother from a certain institution. And he says passionately, I will remember this person if you can show me a contemporaneous photo. We've obtained photos of most of the people it could have been. He has a first name only in his memory, this claimant. And he's looked at photographs of virtually almost everyone who it potentially could have been. and sadly he's not been able to identify the person, but that will not prevent a finding that he was sexually abused.
Well, then can I explore the second limb of this? You've adopted a Briginshaw standard. Now, we lawyers think we know what that means, right? But I'm sure you would accept that the average person in the community wouldn't have a clue what we're talking about.
I agree.
Secondly, I had rather thought, I may be wrong, that in framing your findings by reference to Briginshaw, you have a concern about the adverse nature of that finding in relation to the alleged abuser. Is that right?
It's certainly a factor that what I've called the decoupling that's being proposed or floated as a possibility in the consultation paper of compensation or redress on the one hand and identification of the offender on the other.
If you sued at common law for damages, your abuser, it wouldn't be a Briginshaw standard, would it?
A civil claim, in my submission it would be.
Would it?
I would agree.
Well, that might be an interesting question. What about if you were able to sue the institution for negligence by the institution? Does Briginshaw play a part?
I would have thought so.
Another interesting question.
It becomes a bit subtle because the three classic factors of Briginshaw are the seriousness of the allegation, the gravity of the consequence, etc. The gravity of the consequence for an institution is not nearly as profound as for an individual.
That's the problem, you see. You know what I've identified now for you as a difficulty. The reality of that might be that you could, on your analysis, you could pass a lower threshold to recover against the institution than you might recover against the alleged abuser.
Well, with respect, I would respectfully disagree with that, but
I thought you might, but
Your Honour, at page and Commissioners, at paragraph 43 of our submission, we finished the last sentence. If the offender cannot be identified, the complainant should nonetheless be required to identify, so far as it is possible, the time and place of the alleged abuse. Now, if that takes place and accompanied with the testimony of the survivor that, look, I can't precisely say who it was, but I know it was someone in that institution who abused me, that is sufficient in what we would respectfully say was the application of the Briginshaw process or the Briginshaw standard to find the complaint established.
I guess what I'm trying to work out is whether you have moved to Briginshaw because of a concern about the seriousness of the finding if it speaks against an individual, as opposed to whether or not that's an appropriate standard to adopt for a redress scheme. Do you understand?
Yes, well, if I could, Mr. Gleeson speak in a moment, but we've taken that approach because of the gravity of a person being accused of the heinous crime of sexual abuse. It's not beyond reasonable doubt, it's the lesser test than that.
I understand that, but again, if we go back to the position where the abused cannot actually identify the abuser, the consequence that you're making a finding against the named individual falls away.
Well, but that's a limited number of cases.
It may be, but anyway, we've explored the issue, but I don't think the answer is necessarily where you lie at the moment, but we'll have to think about it.
I'm not surprised, Your Honour.
Yes, sir.
You refer to it's a limited number of cases when the abused can't identify the abuser. There's a greater number of cases where the abused is dead.
Oh, yes. But they're identified.
When the abused is the abuser is identified and dead, you cannot get their side of the story, as it were.
No, that's true.
How do you satisfy the Briginshaw test in those circumstances?
All the Briginshaw test, if you had reached the degree of satisfaction prescribed by the Briginshaw test, yes. And that is very much dependent upon the quality of the testimony of the victim.
Is that what you rely on? What the victim tells you and how they tell you?
Oh, very much so. Very much so. And indeed, when we say we've accounted for 97 or even perhaps a little bit more than that of complaints. That's the test we've applied in many cases.
Many, but not all.
Well, the only ones we wouldn't apply it in is where the offender can't be identified, and we go to the step of saying, well, do we accept the testimony of the complainant? And that's the same position if an offender cannot be identified. Ergo, no contradictory evidence can be given by the alleged offender, in the same way that a man who's in the grave can't give that testimony.
Can I perhaps add that it's been my experience, and I suspect the experience of the Commission, that when a victim of childhood sexual abuse sits in front of you and recounts their story, in the overwhelming majority of cases, there is no doubt that they were sexually abused. And you will readily come to the Brigginshaw standard, having sat and listened and watched. And that's one of the concerns I have about the proposal that's floated, that it be a written application.
Written application doesn't mean that any meeting is excluded.
No, but it seems to contemplate that the default position is that there would be no meeting. Perhaps I misunderstood that.
Assuming that to be the case, you would say that in the absence of speaking to a person who is making a claim of abuse, you couldn't properly decide whether they'd been abused.
Save for circumstances where the abuser is a multiple offender who's been convicted in criminal proceedings and those sorts of situations, if the abuse is not falling into that category, I would find it extremely difficult, if not impossible, to be sufficiently satisfied that the abuse occurred until I met with the person.
What if the institution accepted that it had occurred without requiring you to see the person?
That of course, would be a matter for the institution.
But if I might say, Ms Vaness, that in the situation you pose, where there's a written application and the offender is capable of giving testimony, the best evidence is obviously his testimony or her testimony.
Thank you, Ronald.
Thank you, gentlemen. Thank you for your care and thought and your submission. We have many issues before us which we have to determine, as you know, but we're grateful for what you've been able to provide for us.
We're conscious of that, Your Honour, and thank you for the opportunity.
Oh, sorry, Justice Coates has a question. I got in too early.
Just one matter before we finish, and it falls from the submission touching upon the standard of proof. I've understood that one of the bases upon which you make that submission to us about the Brigginshaw test is that victim survivors may be upset or feel that an apology would be less powerful or less sincere if the standard of proof were to the lower test. So,
well, Ms. Coates, we try to say that in the submission, that it's our belief that if we said to a victim alleging she or she had been abused, look, just tell us about the facts of the abuse. Don't worry about identifying who did it. They would be aghast.
So that's a different question. It's a different question to the standard of proof. So I'll finish my question, which is, on what basis do you put that proposition before us, speaking on behalf of victim survivors, that they would feel that the apology was less sincere?
Based on repeated discussions I've had with victims about the importance of belief, that it's so, I wasn't believed, my parents didn't believe me, or the church didn't believe me. I did tell someone when I was younger, they didn't believe me. At last, now I'm an adult, you believe me. And the belief feeds into the apology. The apology is seen by victims who speak to me as being so closely linked with belief. So if the structure of the system is such that all the system is really saying to them is, you have a plausible complaint, and an institution will say, sorry, I think that would undermine the integrity of the apology.
But Mr Gleeson, is the second part of that proposition your thinking rather than anything that a victim survivor has said to you?
I can't say that I'm so pure as to be able to divorce my thinking about it from what I've heard, but I can say and do say that it's based substantially on what victims have told me. Victims are very anxious to tell us as independent commissioners why they're doing it. Many of them are at pains to say it's not about the money. It's a very common conversation.
But I'm assuming you're not having a discussion with victims about the Brigginshaw test.
Of course not.
Thank you.
Yes, thank you again, gentlemen.
Thank you.
Nothing further today?
Nothing further today. We resume at 10 a.m. Tomorrow morning, Your Honour, with a panel in the middle of the day. Other than the panel, we'll be hearing in a similar fashion as today.
Very well. We'll adjourn until 10 o'clock.
Silence all stand.